Right to remain silent redirects here. For other uses, see you have the right to remain silent. The right to silence is a legal principle which guarantees any individual the right to refuse to answer questions from law enforcement officers or court officials. It is a legal right recognized, explicitly or by convention, in many of the world's legal systems. The right covers a number of issues, centered on the right of the accused or the defendant to refuse to comment or provide an answer when questioned, either prior to or during legal proceedings in a court of law. This can be the right to avoid self-incrimination or the right to remain silent when questioned. The right may include the provision that adverse inferences cannot be made by the judge or jury regarding the refusal by a defendant to answer questions before or during a trial, hearing or any other legal proceeding. This right constitutes only a small part of the defendant's rights as a whole. The origin of the right to silence is attributed to Sir Edward Coke's challenge to the ecclesiastical courts and their ex officio oath. In the late 17th century, it became established in the law of England as a reaction to the excesses of the royal inquisitions in these courts. In the United States, informing suspects of their right to remain silent and of the consequences for giving up that right forms a key part of the Miranda warning. England and Wales. Main article, Right to Silence in England and Wales. The right to silence has a long history in England and Wales, first having been codified in the Judges' Rules in 1912. A defendant in a criminal trial has a choice whether or not to give evidence in the proceedings. Further, there is no general duty to assist the police with their inquiries. At common law, and particularly following the passing of the Criminal Justice and Public Order Act 1994, adverse inferences may be drawn in certain circumstances where the accused fails to mention any fact which he later relies upon and which in the circumstances at the time the accused could reasonably be expected to mention. Fails to give evidence at trial or answer any question. Fails to account on arrest for objects, substances or marks on his person, clothing or footwear, in his possession, or in the place where he is arrested, or fails to account on arrest for his presence at a place. There may be no conviction based wholly on silence. Where inferences may be drawn from silence, the court must direct the jury as to the limits to the inferences which may properly be drawn from silence. In respect of those questioned by the Serious Fraud Office, the right to silence has been reduced by virtue of Section 2 of the Criminal Justice Act 1987. The right has also been reduced for those accused of terrorist offences. The UK has some of the strictest key disclosure laws of the Western world. Under Section and Section of the Regulation of Investigatory Powers Act 2000, RIPA, it is an offence to fail to disclose when requested the key to encrypted data, with a penalty of 2 years in prison, or 5 years with regards to child sex abuse cases.